The Calcutta High Court judgment of 1919 is one which is cited in several Indian textbooks to explain what is meant by prerequisite of design protection. The matter is Gameter versus Controller of Patents and Designs, and the court upheld the claim of novelty or originality for the registered design of a metal wristband for watches, although gold bracelet of the same kind was used as jewelry for several years. The court opined that although the shape of the band was not new or original, but its application to the watch was for a purpose, and this design could be said to be original. So the important aspect is a visual effect when applied to an article in a novel way can satisfy the prerequisite for industrial design protection. The test of novelty as a prerequisite for a design protection has been upheld in the matter of Hello Mineral Water Private Limited versus Thermo King California Pure. The plaintiff claimed that he had registered a design dated 13/5/96 and has sold goods up to May 97 worth 2 crores of rupees and built up goodwill in respect of water coolers. The defendant's design for its water coolers is found to be an imitation and therefore infringing the plaintiff's copyright by using the same design in respect of the same articles, that is water coolers. The defendant claims that there is no novelty in the plaintiff's design, for it was already known and was being used in the market both in India and abroad. However, the courts reiterated that once a design is registered, it is the registered proprietor who can insist that anyone committing piracy should be restrained from doing so for the purpose of the Design Act, and to protect a novelty in the design is to be applied to a particular article to be marketed commercially. So in this case, the article being similar, the design being an imitation, the consumer overlap leads to, in a sense, establishing the case of infringement or design piracy. The novelty, as defined by the court in this case, involves the presence of some element or new position of an old element in combination different from anything found in any prior disclosure or structure. So the different shapes, colors may be used, and the court went on to suggest that this will advance industries and keep high level of competitive progress if the same manufacturers had distinctive designs to then on create aesthetic value and appeal to their respective consumers. While the defendants may use the cylindrical shape of his water coolers, he would use different color combinations, at least of different shades, and place the cup holder in a place which is different from that of the plaintiff, so as to allow the consumer to make an informed choice that the two water coolers are not really coming from the same source. So using holder branded names indicates its names at different place rather than the place as shown by the plaintiff would go on to show good faith on the part of the defendant in the matter. So thereon we have established what is the prerequisite or a test for design protection, the issues of originality and novelty. However, what is excluded subject matter will entail methods or principles of construction. As mentioned, buildings would not constitute designs. So buildings are architectural forms, landscaping or garden designs. These are not what is protectable under industrial designs. Features dictated solely by function. Functionality is an aspect of patent subject and not of industrial design. A mechanical device would also constitute within the realms of patentable subject matter. A trademark, property mark or an artistic work would definitely be protectable under the species of trademark law or copyright law and not designs. And finally, an immoral design or designs contrary to public order. Let's understand some rationale behind excluding certain subject matter from the protection of industrial design, and beginning with methods or principles of construction, and the example I gave was that of buildings. So methods of construction as an exclusion ensures that protection is granted to the appearances of articles rather than to the methods or principles of construction by which an article is manufactured. Therefore, the exclusion draws the line between patent law, which protects inventions, and design law, which protects appearances. The next factor which leads to exclusion of subject matter is features dictated solely by function. So a particular shape is dictated solely by function if its relevant features are brought about by or attribute only to the function which the article in that shape is to perform, even if the same function could be performed by an article of a different shape, it would lead to non-protection. The rule which is followed in this case is known as an every feature rule. A design is unregisterable only if every feature of the design is dictated by function. What it essentially means is if a design is partly functional, it may still be registrable. The overall design has to be looked in order to ascertain that every feature of that design has no necessary relation to the function. Where a design is made up of a number of different features and some of those features are dictated by function, so long as some of the remaining design features are not determined by function, the design will not fall within the scope of the exclusion. A good example worth thinking about is the number of toothbrushes in market. They are designed separately. Some of them have zigzag bristles, some of them have separate arrangements. If those arrangements lead to additive value or functionality of such an article, then that article falls outside the scope of design protection. However, if there is a mere designer handle to a toothbrush, enabling no such extra function of having increased its functionality, such aesthetic or appearance value will be protected under design law. Functional designs. Now this is a case of Escorts Constructions Equipment Limited versus Action Construction Limited, 1999, PTC 36 of Delhi, where the Delhi High Court had the occasion to interpret this clause and opined that the expression design does not include a method or a principle of construction of features or shape or configuration which are dictated solely by function, which the article to be made in that shape or configuration has to perform. So according to the court, the definition made it amply clear that the primary object of the act was to protect aesthetic shape and not function or functional shape. And so the grounds of non-registrability of the designs would be if a design is not new or original, or there has been a prior disclosure and so the public knows about such a design from before, if it is non-distinguishable from known designs and is scandalous or obscene, then in that case it is excluded. What do you mean by not new or original can be understood that the primary requirement is that the design must be new in respect of the class of the article to which it has been applied. The novelty or originality is judged on the basis of expert evidence, which means that only an expert who is well versed with the design or the common trade practices and usages in the class of goods to which this design is applied would be the one entitled to pass a verdict on the novelty and originality. The element of prior disclosure essentially means that when a design is not previously published in India, then the publication would actually require that the design is available to the public or it has been shown or disclosed to anyone who is not bound to keep it secret. Then such design will not be considered registrable. Such publication can be made in any prior document or even prior use. Therefore, in a sense, publication would mean the opposite of being kept secret as held by the Delhi High Court in the matter of Vimco Limited Bombay versus Meena Match Industries. The disclosure, even to one person, is sufficient to constitute publication. Prior disclosure is a very strong element for non-registrability of industrial designs. Section 4 goes on to further give elements of non-distinguishable from known designs. In case of a combination of previously known designs, it will qualify as a registrable only if such combination results in a new visual appeal. Therefore, it has to be distinguishable from known designs or combinations of known designs or comprise. And finally, a scandalous or an obscene design is not protectable under Indian law. That would mean anything which hurts the moral sentiments of the nation or the people of India will not be protected under design law, no matter how aesthetic. Let's understand the requirements for cancellation of registered designs. While we have understood what is not registrable, what leads to revocation or cancellation after the grant of a design right. The Act does not provide for advertisement of the application, for registration or for the opposition to the registration, and that's a new kind of a provision because most of the intellectual property laws have an objection clause prior to grant. However, any interested person can file a petition to the controller seeking the cancellation of a registered design. This application for cancellation is admissible only on the following grounds: that the design has been previously registered in India, that is, it has already been used priorly by someone else, that the design has been published in India or any other country prior to the date of registration. This enhances the bar for novelty. The novelty for industrial design has to be worldwide, and that the design is not new or original design, and if it is, not registrable under the Act as per Section 4. In the matter of Western Engineering Company and Paul Engineering, which is a 1968 Calcutta High Court judgment, the registered design for a cycle lock was cancelled due to lack of novelty or originality, and also for prior publication. It's one of those rare cases when a granted industrial design is cancelled out for not adhering to the statutory norms.